Good afternoon, everybody, and thank you for joining us for Conn Carey's webinar today regarding joint employers, independent contractors, temporary workers, and multi-employer labor and employment and OSHA issues. This is the sixth webinar in our two concurrent webinar series, the 2018 OSHA webinar series and our 2018 labor and employment webinar series. It's one of my favorite times of the year when we have this overlapping topic and we get to showcase the two great areas of expertise at Conn Carey, where there's these issues where there are major labor and employment components and OSHA components. And in that circumstance, I'm very pleased to be joined today by my partner Jordan Schwartz from our labor and employment practice here at Conn Carey, and our associate Lindsay DiSalvo, who practices in both the OSHA and labor and employment practices. And my voice, the faceless voice you're hearing right now, this is Eric Conn. I'm one of the founding partners and chair of the OSHA workplace safety practice here at Conn Carey. I'm going to let Jordan and Lindsay introduce themselves, and then we'll dig right in.
Thank you very much, Eric. Again, my name is Jordan Schwartz. Hopefully some of you have heard me speak on various topics over the last few years, including this topic. Generally, I defend employers in all sorts of employment-related issues, both litigation, whether it's litigation under Title VII, the wage and hour issues under the Fair Labor Standards Act, disability issues under the ADA, and really just all sorts of litigation arising under the hiring and firing process. And also I counsel employers on that same hiring and firing process and make sure that you all are complying with local, state laws as well as federal laws. And as you'll see in this presentation, there's also a union component, and I advise unionized and non-unionized workplaces on making sure to comply with the National Labor Relations Act.
All right, good afternoon, everyone. I'm Lindsay DiSalvo, and as Eric said, I'm an associate in both the labor and employment practice as well as the OSHA practice. I also advise and counsel employers on all aspects of the employer-employee relationship, including wage and hour issues like some of the ones that we'll actually be talking about today. And then I also review policies, handbooks, and determinations regarding employee classification. On the OSHA side, I assist with OSHA inspections and enforcement actions, and similarly review safety policies and procedures for employers.
As I mentioned before, I'm Eric Conn. I head the OSHA practice here at Conn Carey. My practice focuses essentially exclusively on matters of workplace safety and health, primarily working with employers to help manage inspections, investigations, and enforcement actions involving OSHA and the litany of alphabet soup of other agencies that get involved in workplace safety issues, primarily also the other approved state OSHA programs, as well as the Chemical Safety Board and the EPA. We also work, unfortunately, sometimes work with employers in counseling through potential criminal matters brought by the DOJ under the OSHA Act or otherwise, and we also provide counseling on safety and health compliance matters. I'm going to let Jordan take the lead on today's presentation, run us through the agenda, and get us started.
Great. Thanks, Eric. The first thing I will focus on is what I've termed the Department of Labor's new joint employer standard. And that new maybe should be in quotes because it's arguable if it's new or if it's old or if it's just a reversion back into one of the two. But I will get into that in much more detail momentarily. Then Lindsay's going to talk about independent contractor issues. And then Lindsay and Eric will talk about OSHA issues, specifically the temporary worker initiative and also OSHA's multi-employer worksite enforcement and issues surrounding that. But let's start with the joint employer standard. Some of you may have heard this presentation before, and the reason why we're doing the similar presentation this year is because the law keeps on changing. This happens in various areas of employment law. but this specific issue, it is really, I don't know if I've ever seen an issue kind of waffle and go back and forth so many times. If some of you heard one of our presentations 2 or 3 years ago, we might be now talking about similar issues, whereas if some of you only heard it last year, you might be further in the dark just because of the way things have changed. So we thought it was important just to really give you a lay of the land, explain what's happened the last few years and where we are right now and what we can expect from the current administration and makeup of the board going forward. But in case some of you are just new to the general joint employment issue in and of itself, let me just take a minute to explain that before I get into what the law is. And really what we're talking about is, many of you often use a staffing firm or a contractor to outsource tasks. And we've advised on that over the years that that's a terrific way to fill in some gaps in your workforce, without the hassle of hiring a full-time employee and needing to get into all the various difficulties associating with hiring such an employee if you actually don't need one. But if you do hire use a contractor or a staffing firm, what you need to think about is which entity is the rightful employer of the outside worker. Is it the third-party firm, or is it the company that hires the individual, or is it both? And kind of, in short, it's just the question is when there's at least 2 companies that are partly responsible for employing the same staff member, and each of these contractors or each of these employers have some sort of control over the tasks and employment conditions of the worker, who is liable? Which company is considered a joint employer? And we're talking about legal obligations. What happens if if the employee fails to get paid? Who will the employee sue? And from your perspective, more importantly, which employer will be found to be liable? What about legal obligations about collective bargaining agreements? What about renegotiation of terms and conditions of employment and contracts? So if you're found to be the employer, you will have to honor these obligations and potentially be liable, even if you didn't even realize you were the employer. So that is what the overall issue we're going to be talking about here. And I see someone asked if you guys will be getting a copy of the presentation. And once we are done with this presentation in a day or two, we will certainly send out an email providing a copy to everyone on the line here. So a little bit of history. In the past few years, let's say up until 2018, but really starting in 2014, both states and federal agencies have really been broadening the joint employer relationship. I have here in September 2014, the NLRB, the National Labor Relations Board, really for the first time expanded the definition of a joint employer to include a company's use of a contractor or worker, even if the company exercised, not only if the company exercised direct control, but even if the company exercised indirect control over the essential terms and conditions of employment. So that kind of started the slippery slope that we've been going down, which is whether you can be liable as a company even if you do not exercise direct control over the terms and conditions of your employees or of your workers. There was the first CNN case, which has since been overruled. Then I'll talk in a minute about the Browning-Ferris case and what's happened since. But beyond federal agencies, many states also have broadened the joint employer relationship, and that's something you really need to pay attention to depending on the state in which your company has employees. For example, in the past, prior to 2015, workers in California could only establish liability against the company by showing that an actual employment relationship existed both with the labor contractor that employed the temporary worker and with the company to which the worker was assigned to perform services. And usually you had to show the company to which the worker was assigned needed to exercise significant and direct control over the worker's wages, hours, and other working conditions. But now for most violations in California, this is no longer necessary. And if you are an employer in California now, you likely can be deemed liable even though the third-party contractor is the entity that's actually hiring and controlling the temporary workers, no matter what actual control you as a company exerts over those temporary workers. For example, as for, let's say, wage payments, you can now be liable for failure to compensate an employee even if you have no control over and you don't even participate in the payment of wages to a temporary worker hired by a contractor, which, as you may know, that often is the case. So that's why this issue is of significant importance here. But let's go into the NLRA here, which is, I'll talk a little bit about the FLSA and Title VII, but really we're going to focus on the NLRA because that's where most of these issues have come to a head. The old standard, let's say basically for most of the time up until 2014 or 2015, was that entities were joint employers if they shared the ability to control or to co-determine matters governing essential terms and conditions of employment, such as hiring, firing, discipline, wages, supervision, and direction. So the control had to be actual, direct, and substantial. Theoretical control or possible control wasn't part of the equation at that time. The relevant inquiry was just whether your company exerted a significant and direct degree of control over a worker. Then, and most of you, if you've been paying attention the past couple of years, probably know about this Browning-Ferris decision. And that happened in the summer of 2015. And in that case, Browning-Ferris, which is it's a recycling facility that used temporary workers from a different company. The company was called LeadPoint. And LeadPoint employees performed different tasks than Browning-Ferris's regular employees. Also, LeadPoint's employees were supervised, hired, and fired by on-site LeadPoint management and LeadPoint HR representatives. But the board found that because Browning-Ferris subjected LeadPoint's hiring decisions to its own criteria and reserved the right to dismiss temporary workers, even though they didn't act on that right, the board found that the two companies were, in fact, joint employers. So this new expanded test basically says that two or more entities are joint employers under the National Labor Relations Act if, one, there is a common law employment relationship with the employees in question, and two, the putative joint employer possesses sufficient control over employees' essential terms and conditions of employment to permit meaningful bargaining. But aside from that, you really need to go into the weeds of the actual decision, and I've cut and pasted the few key quotes from the decision that you really need to be aware of. And what the board said, as you can see here, is we will no longer require that a joint employer not only possess the authority to control employees' terms and conditions of employment, but also exercise that authority. And that's kind of a confusing sentence, but if you read it over a couple times, you can understand what it means. And it goes on to say, reserved authority to control terms and conditions of employment, even if not exercised, is clearly relevant to the joint employment inquiry. The board goes on to say that nor will we require that to be the relevant joint employer inquiry, a statutory employer's control must be exercised directly and immediately. If otherwise sufficient, control exercised indirectly, such as through an intermediary, may establish joint employer status. So, under this new joint employer test that I'll get to in a minute that actually is still the law right now, despite a flurry of recent activity, under this new test, an entity can be deemed a joint employer if, one, it does not actually exercise any control over employees' terms and conditions of employment, but based on a contract or otherwise, theoretically could exercise some control, or two, it does not exercise any control, but rather exercises control through a third party. So if you weren't aware of this previously, you really need to review your contracts and your relationships with staffing companies and outsourcing partners to identify and assess legal risks based on this test and take immediate action to mitigate or eliminate those risks. For outsourcing relationships, in order to avoid joint employment, one thing you might want to do is focus on ensuring that you do not interfere with the hiring and firing of the third party's employees. As long as a contractor doesn't violate laws, it really essentially shouldn't be your concern as to who they hire and fire. Similarly, with staffing workers, you want to be sure they have clearly delineated functions they'll be performing, as well as the limited length of the job, which that job should be not only relatively short, but also for a defined period of time. Quickly, another case that happened pretty soon after Browning-Ferris was this case called Miller and Anderson, which is interesting because it bolsters the impact of Browning-Ferris, because Browning-Ferris made it easier for a company to be considered a joint employer. And here, Miller and Anderson made it easier for employees to unionize once that joint employer relationship has been established. And what the case found was that temporary employees could form a bargaining unit with regular employees without employer approval if they share a community of interest. So if you had some temporary contractors that hardly had any interaction with you, all of a sudden you might be the employer that is employing a unionized workforce. So that is something that was an extremely interesting case. But now let me fast forward up until 6 months ago, December of 2017, when a new case came out called High Brand Industrial Contractors. And that case is one of the first cases decided by the new Republican majority of the board, which now includes Marvin Kaplan, who previously served as a Republican Workforce Policy Counsel for the House Education and Workforce Committee, and William Emanuel, a former partner at Littler, who was actually Littler was actually one of the firms involved in the Browning-Ferris decision. And what High Brand did was it restored the joint employment standard to what I've put here as the pre-Browning-Ferris standard. So under High Brand, 2 or more entities would be deemed a joint employer only upon proof that one entity had direct and immediate exercise of control over the terms and conditions of employment. The board in that case clarified that proof of indirect control or control that is limited and routine was not sufficient to establish a joint employer relationship. So, but hopefully some people who aren't on this call haven't seen High Brand and just assumed that was the law without continuing to pay attention, because a few months later, and what's really never happened before, it was an unprecedented move, the board actually vacated the high brand decision. What happened was there's an ethics official that's part of the NLRB, and they determined that William Emanuel, since he was previously affiliated with a partner at Littler, he should have been disqualified from participating in the proceeding due to Littler's involvement in the Browning-Ferris case. So because of that, all of a sudden now the joint employer standard has now reverted back to the standard established in Browning-Ferris. So everything I told you a few minutes ago about the indirect control, that is still the law. It's arguable as to how long that will be the law, because the board will probably use another case at some point, in the future to try to reverse it, but there's no telling exactly when that will be. Interestingly, just last month, the Office of Information and Regulatory Affairs released the Trump administration's unified regulatory and deregulatory actions agenda. And what that agenda does is it identifies and explains rulemaking activities in which each agency plans to engage over the remainder of 2018 and into the next year. And possibly due to this, increased activity in this joint employer arena, on the action list is now a rulemaking to establish a standard to assess joint employer status. There's been no date yet projected for this rulemaking. They just said that they hope to move forward as soon as possible. So we'll see what happens in this agenda. If some type of joint employer standard is established by this rulemaking, it certainly stands to reason that it would be more akin to the control model, the direct control model versus the indirect control standard established by Browning-Ferris. But at this point, we're just not. I think it's more likely that a new case will happen before this rulemaking happens. And real quickly, just my last couple minutes here before I turn it over to Lindsay, I just want to let you know that there also are other areas of the law where this is affected besides the NLRA. For example, the Fair Labor Standards Act. Interestingly, 2 years ago, the DOL issued a memo supporting what's called an economic realities test for determining joint employer status under the FLSA. And that test examines whether a worker is economically dependent on the purported employer, and it is not only concerned with control. Specifically, it talked about a whole panoply of things, including the permanency and duration of a relationship, repetitive and rote nature of work, whether it's integral to the business. But similar to what's going on here, that has now been rescinded. So it's not. There's no real clear delineation right now what the DOL is looking at from the Fair Labor Standards Act perspective. From Title VII, this is more of what courts do to assess joint employers, and similar to the DOL, they just look at they look at everything: the authority to hire and fire, the day-to-day supervision, the control, even who's paying, to try to determine if you have any liability from a joint employment standard under Title VII. And again, this slide is just talking about how the Fair Labor Standards Act has now been rescinded. But why I said it's a little ambiguous as to what the standard is. The DOL emphasized that while the removal of that memo happened, it does not change the legal responsibilities of employers under the FLSA. The only thing it doesn't really explain is what are those legal responsibilities. So that's really still an open question under the FLSA. And finally, my last slide is there is new potential legislation on this issue based on the fact that Browning-Ferris generated so much controversy among employers. And for that reason, the GOP led this effort to promulgate what's called the Save Local Business Act. And that is trying to codify the narrow joint employer definition. That act passed in November in the House and actually received a handful of votes from Democrats. But it's unclear and I think unlikely that it will make it through the Senate. But Republicans are still trying to make headway in persuading, some of the more centrist Democrats to hop on board. So what I'll just finish by saying here is this is an issue that you need to follow the courts, you need to follow what the board is doing, and you need to follow what potential new legislation is doing, all to make sure that you aren't potentially exposing your own companies to some sort of liability based on this almost sporadic up and down enforcement of these joint employment issues. With that in mind, I'm going to turn it over to Lindsay to talk about a related issue based on whether or not how you should classify independent contractors.
Thanks, Jordan. So another significant issue for any discussion related to employment relationships is the classification of workers as independent contractors under the Fair Labor Standards Act. It can be very challenging to determine if a worker is properly classified as an independent contractor, and the ramifications of misclassification can be quite significant for employers. So specifically, the Fair Labor Standards Act provides certain rights for employees that apply to all workers that are classified as employees based on the definition provided in the Act. For instance, the Fair Labor Standards Act, or the FLSA, requires that employers pay employees at least the federal minimum wage, as well as overtime for all hours worked in excess of 40 hours per week. The FLSA, however, does provide an exception to those requirements for workers that are properly classified as independent contractors. So in other words, the FLSA does not require employers to pay independent contractors the overtime payment if they work more than 40 hours a week, or the federal minimum wage. But in treating workers as independent contractors, employers do run the risk of misclassifying them. Proper classification is really important for an employer because a worker could claim significant lost wages and overtime under the Fair Labor Standards Act if they are improperly classified. They could also potentially claim liquidated damages and the amount of any wages that are owed. So basically, they could be entitled to double the wages that they're owed if they are misclassified. And this type of claim, particularly where there's more than one worker that might have been misclassified or is claiming that they're misclassified, could be potentially very costly to an employer. Collective actions brought under the Fair Labor Standards Act by employees that were similarly misclassified could mean potentially millions of dollars in damages for an employer, depending on the size of the group that brings the action. And then beyond lawsuits, you also have the Department of Labor, who can actually independently investigate allegations of worker misclassification on its own, and then potentially pursue a lawsuit depending on the outcome of that investigation. Under the Obama administration, addressing misclassification of independent contractors was a priority of the Department of Labor, and this was demonstrated by the fact that they had the Department of Labor's Misclassification Initiative. And this was basically the Department of Labor working with the IRS and state agencies to enforce and investigate issues of wage and hour violations. It doesn't appear to be as significant a focus under the Trump administration. The misclassification initiative does still exist, but many of the state memorandums of understanding basically that were put in place to have this enforcement relationship with the Department of Labor have expired and have yet to be renewed. This is not to say that the independent contractor misclassification issue is no longer a focus. Because it does tend to be such a confusing area of the law and misapplication is quite common, those issues do tend to come to the attention of the Department of Labor. So in evaluating whether a worker is an independent contractor, there are several different tests that are used. The IRS has a test, the Supreme Court has a test, and then state laws and state agencies also have their tests. But the factors that are considered from test to test tend to be very similar. Within the Department of Labor, FLSA is enforced by the Wage and Hour Division. And in assessing whether a worker is an independent contractor, the Wage and Hour Division's goal is to determine whether the worker is economically dependent on the employer. If the worker is economically dependent on the employer, then they should be classified as an employee as opposed to an independent contractor. All the factors that are considered must be considered together in making a determination on classification. There is no one factor that is more important than the other. Ultimately, the Department of Labor may disagree with an employer's evaluation of the factors it uses in classifying a worker as an independent contractor, but careful review of the factors and documentation of this evaluation can be used to support the employer's position if a question on classification should arise. So these are the factors that have been identified by the Department of Labor as those generally considered in determining whether an employment relationship exists under the Fair Labor Standards Act. I'm just going to go briefly through each one so we have a better understanding of what each factor means. So the first factor you have here is the employer's nature and degree of control over the worker. The first factor addresses who sets pay amount and work hours, who determines how the work will be performed, and whether the worker is actually free to work for others while they have an employment relationship with the current hiring entity. An independent contractor does have to control all the meaningful aspects of their work for the employer. So that is things such as setting their own hours, determining how they're going to actually perform the tasks that they have been hired to perform. Generally, if an employer dictates how and when the work should be performed, that worker is going to be classified as an employee as opposed to an independent contractor. The second factor is the extent work is performed is integral to the employer's business. So if the work performed by the worker is integral to the employer's business, then that worker is going to be more likely to be seen as an employee because they're economically dependent on the employer and not really in business for themselves. For example, if the employer happens to be a large retailer and the worker who is hired sells the retailer's product, that type of work is really integral to the particular business of the employer, and thus that worker is more likely to be seen as an employee. A worker hired to repaint the inside of a store, for instance, or fix, an electrical issue that arises in the store, that worker will probably be seen as an independent contractor because although their work is important, it's not integral to the actual business of the employer. The third factor is permanency of the employment relationship. A short defined relationship tends to suggest an independent contractor status versus a permanent and indefinite employment relationship, which would be more likely to support an employee as opposed to an independent contractor. Then the fourth factor is the worker's investment in equipment and facilities. An independent contractor should have their own business investment in the work and equipment that they're using to perform the tasks for which they're hired so that they share in the risk of loss. If a worker is providing his own equipment to perform the work, that would tend to support an independent contractor status. but it doesn't necessarily prove that the worker is an independent contractor in and of itself. For example, if the employer reimburses the worker for the purchase of that equipment, then this is more likely to support that the worker is actually an employee. And the fifth factor is the worker's opportunities for profit and loss. This particular factor focuses on the worker's ability to exercise managerial skills and their own independent initiative and judgment on the job. If they are exercising those types of skills, then it's going to be more likely that they're an independent contractor because it gives them the opportunity for either profit if they're more efficient at a job or loss if they're less efficient at a job. And then finally, the last factor is going to be the level of skill, initiative, and independent judgment. If a worker demonstrates that they constantly exercise independent business judgment, they take initiative to operate as an independent business and market themselves, that worker is going to be more likely to be seen as an independent contractor. Employers should not have to provide skills training to an independent contractor. That person should be hired for the skills they already have. And if the employer is training the person to perform the particular task for which they've been hired, that's more likely to demonstrate an employment relationship. And again, just to emphasize, all of these factors have to be assessed together in determining whether there's an independent contractor relationship, and no one factor is more important than the next. These are all sort of things you consider together and weigh against one another. So then once a worker has been classified as an independent contractor, there are important steps an employer should take to effectively establish and maintain that relationship. The first here is memorialize the terms and conditions of an independent contractor relationship in a contract. Even where that has been done, courts have found an employment relationship still exists between the worker and the employer, but it does, it's important support for the fact that this should be treated as an independent contractor relationship. Those types of contracts should be signed by both the organization or the employer that's hired the worker as well as the worker, him or herself. It should include all of the important terms and expectations of the work to be performed by the independent contractor, and it should include a specific acknowledgement that the independent contractor is not an employee. The next is establish policies to limit direct control of independent contractors. You're going to want to establish those policies and then make sure that managers are actually trained on those policies and understand that they are not supposed to be directing the work of independent contractors. Establish fixed limited duration employment relationships. You want to try to have the terms of a relationship with an independent contractor relatively set. And once you do, that is another term that should be included in the contract with the independent contractor. And then limit interaction between employees and independent contractors. You want to make sure that there's a clear separation between employees and independent contractors. That might mean separate communications, emails to employees versus independent contractors, and exclusion of independent contractors from social events that are put on by the employer. And then finally, just review policies to make sure they don't cover independent contractors. Policies like leave should not cover independent contractors. Those are only for employees. And benefit plans should not include independent contractors, and that should be clear to workers who come on to perform tasks as independent contractors. As I stated prior, it does appear that this administration is already pulling back its focus on misclassification, including the expansive definition of who is employee versus an independent contractor that was promoted by the prior administration. Specifically, back in July 2015, the Wage and Hour Division published an administrator's interpretation, and that interpretation explained the analysis that should be used in evaluating whether someone is an independent contractor. In that interpretation, the Wage and Hour Division concluded that due to the broad definitions of the terms under the FLSA, like employ, most workers are in fact employees, and this interpretation created the presumption that workers should generally be classified as employees. However, in June 2017, Current Secretary of Labor Alex Acosta withdrew this interpretation, and in the press release that discussed this withdrawal, it explained that withdrawing the letter did not change the employer's legal obligations under the Fair Labor Standards Act, but the decision to withdraw the letter does indicate a potentially narrower interpretation of terms like employ and employee in this context. But we haven't seen any sort of follow-up guidance as a response. And finally, although this administration does appear to be pulling back, California has actually moved in the opposite direction under its state wage orders. On April 30th, 2018, the California Supreme Court established a new standard for determining whether workers should be classified as employees or as independent contractors. Historically, California had actually used a multi-factor test similar to those tests that I discussed earlier that are used by other states, similar to the tests used under the federal law that looks at the right of control over the manner and means of the work being performed, the method of payment, the duration of the relationship, as well as the kind of work that's being performed. However, in the case of Dynamex Operations West, Inc., the court imposed a different and much more inflexible standard for determining whether workers should be classified as employees or independent contractors under California's wage orders. The court held that based on the definition of employ that is contained in the wage orders, a worker should be considered an employee of an entity that has suffered or permitted the worker to work in its business. And then in further interpreting that term, the term suffer and permit to work, the Supreme Court found that it should place the burden on the hiring entity to establish that the worker is an independent contractor who is not intended to be covered by the wage order as opposed to an employee. Then the Supreme Court went on to establish a three-part test that should be used in making this evaluation, and that should be used by employers in meeting this burden of showing that someone should be treated as an independent contractor. The first factor requires that the worker is free from the control of the hiring entity, which is something that's a similar factor under other state tests as well as the federal law that we discussed a little bit earlier. The second factor requires the worker to perform work outside the usual course of the hiring entity's business. So a similar factor to what we talked about with the federal test. However, in this case, it is one of the things that must be met in order for someone to be an independent contractor. Thus, even if the worker has a specialized skill and does not perform work under the direction or control of the hiring entity, the mere fact that the worker's services are part of the entity's usual course of business would defeat the independent contractor status. And then finally, under the third factor, this also presents a really significant hurdle to establishing that someone should be considered an independent contractor because it requires the worker to be customarily engaged in the work it could perform through his or her own independently established occupation or business. Thus, this factor suggests that the worker would need to establish some sort of independent business entity or identity to be hired as an independent contractor. So with this newly recognized standard, the court did provide, I think, greater clarity than the previous multi-factor test, but it does impose a really high burden for employers seeking to classify workers as independent contractors. And importantly and significantly, it may end up being the benchmark for California as well as other states that want to impose a higher, more rigid standard for assessing independent contractor status. Businesses in California, owners and management should immediately review the current independent contractor arrangements that they have to ensure that proper classification under this new three-factor test. Because decisions to treat a worker as an independent contractor that are motivated by financial reasons or where the person actually works, or even a lack of control exercised by the hiring entity may no longer be sufficient. It's likely that those standard independent contractor relationships like attorneys or accountants will be found to meet this new standard, but employers should take a close look to make sure that that's the case. And I'll now turn it over to Eric to talk about the Temporary Worker Initiative.
Thanks, Lindsay. This is one of these categories I'm going to talk about today where if you've been following along the OSHA webinar series or following along our blog, you've heard a lot of talk lately about how the more things change, the more they stay the same. That as we transition from the Obama administration to the Trump administration, there was an expectation of significant changes at OSHA, maybe a contraction in enforcement, maybe delivering on the campaign discussions about deregulation and retiring old rules and regulations and enforcement policies. But the reality is, a year and a half into the Trump administration, we've seen very little change at the agency. There was a lot of sort of a flurry of activity in the first few weeks, first few months of the new administration, primarily under the use of the Congressional Review Act and some executive orders. But since that time, we still don't have a Senate confirmed Assistant Secretary of Labor for OSHA, and we have seen very little change in enforcement initiatives and in the approach and the philosophy that the agency brings to safety and health. So this OSHA Temporary Worker Initiative is another thing that has changed very little as we transition from one administration to the next, but I want to make sure everyone's aware of what's going on and what this means and where it came from. And where it came from was a general concern by the agency, by the senior leadership during the Obama administration at the agency, about how temporary workers were being utilized and some of the unique hazards that they were being exposed to. And the expression by OSHA about why there was a need for a temporary worker initiative was because the agency had this belief that employers were using temporary workers to skirt their OSHA Act obligations. In other words, these are not my employees, so I'm not obligated to provide training, I'm not obligated to provide PPE, I'm not obligated to provide them safe working conditions. My experience with employers is that that's not true and that I've not observed that personally, but that was OSHA's belief and why there was a need for this initiative. There was similar beliefs by OSHA that employers were out there utilizing temporary workers specifically for the most hazardous jobs at the workplace. So if they don't want to use their permanent staff either for morale issues or for whatever reasons, that they would bring in temporary employees or temporary workers from a staffing agency and have them do the dirty jobs or the unsafe jobs. Again, not consistent with my experience, but that was OSHA's belief as to why such an initiative was necessary. And then likewise, OSHA has a concern and continues to have a concern that temporary workers are uniquely vulnerable to workplace hazards and uniquely vulnerable to retaliation. Their relationship with the workplace and with the employer is more tenuous than a permanent employee. Their protections are more tenuous than a permanent employee, and so they will be more susceptible to retaliation and less likely to speak out and identify unsafe working conditions, and so they are more vulnerable to those experiences. And that's why a temporary worker initiative may be necessary. And then as a result of sort of those beliefs about the philosophy as to why and how these workers are being used, OSHA has the belief that those types of workers are not getting the same level or even an adequate level of training or explanation about their duties, working conditions, or hazards that might be present by the host employer in these staffing agency temporary worker relationships, and that they're not being given adequate training and explanations of their duties and potential hazards of the workplace by the staffing agencies, because the staffing agencies simply cannot provide that because they are not knowledgeable enough about the unique hazards or the unique tasks to be performed at a host employer site. And then anecdotally, and I do say that with meaning, I think it's anecdotal, not statistical, but OSHA pointed to and continued throughout the life of this initiative to point to anecdotes of serious and significant injuries involving temporary workers on the first day on the job. And I don't think it's technically necessarily the first day, but in the first days or weeks on a new job, that there is high rates of injuries. And there is some reality and some statistical support that injuries are more likely to occur on the first days of a job, not just involving temporary workers, but involving any worker, because that is when you are the least experienced, not only with the task, but least familiar with the potential hazards at the site, regardless whether you're hired as a permanent employee or a temporary worker. But as a temporary worker, you are more likely to move from one workplace to another more often, so you have many more of these first days on the job windows of time where this higher likelihood of incidents may be present. And then the other reason why OSHA believed it was necessary to implement a temporary worker initiative is that there was a growing and a forecast for a even more significantly growing use of temporary workers in America's workforce. And one of the major motivators of that growth in the use of temporary workers was the implementation of the Affordable Care Act. And this is one of those areas where it's worth sort of understanding what's happened during the Trump administration, because we know that there have been some changes to the Affordable Care Act, although not the full-scale repeal that had been advertised by Trump during his campaign and by the Republicans in Congress every day, not just during campaigns. And there has been a repeal of the individual mandate under the Affordable Care Act, but there was no change at all to the employer mandate under the Affordable Care Act. And what that means is there is still an obligation by employers who have 50 or more full-time employees to provide either insurance that meets the standards of the Affordable Care Act or to pay a penalty for not providing that insurance. And that concept that if you have 50 or more full-time employees, you have some significant obligation under the Affordable Care Act has motivated some employers, and this is a historical circumstance as well. When the Massachusetts version of the Affordable Care Act was implemented, Massachusetts employers utilized more temporary workers than they had historically, and already in the implementation of the Federal Affordable Care Act, we've seen this increase in the use of temporary workers. And the idea is, if I'm close to that edge, if I'm close to 50 FTEs, rather than hiring 1, 2, 3, or 4 more employees and going over that threshold, I might utilize more temporary workers at a less than full-time employee, man hours worked relationship to stay just under the cusp of that coverage under the Affordable Care Act. And so we've seen some increase in the use of temporary workers for that reason, and forecasting that that was going to happen, OSHA said we need to make sure that temporary workers are protected on the job, because there's going to be a whole lot more temporary workers on the job. And so this temporary worker initiative was born. It was initiated during the Obama administration. It continues, I would say, perfectly unchanged so far during the Trump administration. We'll talk about what that means so far the first year and a half of the administration. The initiative itself covers a specific temporary worker relationship. It is temporary workers who are supplied by a staffing agency. There are other types of worker-employer relationships that are effectively temporary worker relationships, but this initiative covers specifically that staffing agency relationship. The expressed goals of the initiative by OSHA were to protect temporary workers from workplace hazards, to help staffing agencies and host employers understand their respective safety obligations, and for OSHA to identify and understand which industries are utilizing temporary workers more than others, in what way they're utilizing them, and what unique hazards might temporary workers face in workplaces in America. So the initiative is different than many enforcement initiatives we've seen from OSHA. This is not a national emphasis enforcement program, not a regional enforcement program. It's an initiative, and much of the initiative is based on education and compliance assistance for industry, for employers, for host and staffing agency employers, for temporary workers as well, to understand their rights and some of the hazards they might encounter. It's an information gathering initiative, identifying where there are greater risks, where this relationship is being utilized more. But there is also an enforcement component to it as well. The enforcement component, well, really the enforcement component and the information gathering component are all driven by this activity that's happening in the field by OSHA's compliance, safety, and health officers, who have been instructed under this initiative to determine in the course of essentially all of the inspections that they are conducting, regardless of how they were initiated, and that means that they are not initiated technically as part of this initiative, but all of their inspections, the inspectors are supposed to be looking for the presence of temporary workers, the presence of this work relationship at the workplace, even if it had nothing to do with the reason why OSHA was there. It's not related to an employee complaint that brought the inspector there, or an incident, or some other programmed inspection. They're supposed to keep their eyes out for, and in fact, early in this initiative, we were seeing a very express document and information request in the first wave of requests that asked this specific information. We're seeing that a little bit less now than we used to, but there is supposed to be some probing by the inspector into whether there are temporary workers present, to identify whether those temporary workers are exposed to any unique violative conditions, whether those temporary workers are receiving adequate training, and training in an understandable language. There's this understanding by OSHA that there is, again, that vulnerable workforce. Often temporary workers are not English speaking, or English is not their first language. And so OSHA is looking to see whether whatever training is provided in a language they can understand. And then it's to gather and document the names, the locations, and the structures of the staffing agencies and the types of employers and the industries that are using these staffing agency supplied workers, and then to do an analysis of whether these temp workers that are maybe brought in with the understanding by the employer that these are not my employees. Well, OSHA is doing an analysis to say, well, it's nice that you think they're not your employee, but we're going to do our own analysis to see whether they are and to see who's responsible for any potential workplace violations. We talk about this as a partial enforcement program and a partial compliance assistance education program. Here's the data around the enforcement side of the program. And what this shows is the numbers of inspections that have been coded in OSHA's database as being related to this temporary worker initiative. And OSHA has broken it down by inspections of host employers under the temporary worker initiative and inspections of staffing agencies under the temporary worker initiative. And these are calendar year data points, and you can see that there are hundreds and indeed more than 1,000 inspections in the first couple of years of the initiative coded under the temporary worker initiative. And then there appears to be a very significant drop-off in 2017 for these types of inspections. I'm told by the folks at OSHA that this might be more of an illusory drop-off than a reality, that OSHA changed the way that they sort of count inspections between 2016 and 2017, and my understanding is that what they're talking about there is the change in the, what do they call it, the inspection weighting program, weight like, heavy and light weighting, where they assign inspection units for some inspections versus others. And so my understanding from the folks at OSHA is they believe they are still performing essentially the same number of inspections under the initiative, but they're just counted differently. But take for your own what these numbers would suggest about what the initiative is doing. But it is a significant number in any year here in which OSHA is exploring this relationship between host employers, staffing agencies, and potential OSHA violations. I'm not going to go into a great deal of detail about this analysis that OSHA does about whether the host employer is the employer of these workers, because it's essentially the same kind of analysis that Jordan talked about under the FLSA and that Lindsay talked about in the context of the independent contractors. The major question that OSHA asks, or more importantly, the major question that the OSHA Review Commission asks in determining whether a violation belongs at the feet of the host employer or the staffing agency, is which employer has the right to control the manner and means by which the work is accomplished by the temporary worker. And here's the factors that are considered in sort of rolling up to that ultimate question of, does the host employer have the right to control the manner and means? At the end of the day, the big takeaway that everyone should have from this temporary worker initiative by OSHA is that OSHA believes that both the host employer and the staffing agency have joint responsibility. And what they're saying here is that the host employer needs to treat temporary workers as they treat existing employees. Because staffing agency and hosts share control over the employee, they are jointly responsible for temporary employees' safety, and it is essential that both employers comply with all relevant OSHA requirements. That's a quote from Dr. David Michaels, Obama's longtime Assistant Secretary of Labor for OSHA, sort of announcing and explaining what this temporary worker initiative is all about. That is the overarching concept. And then, as part of the initiative, OSHA put out guidance in certain areas that explain what they mean by this joint responsibility. And so, for one example, is training. And in the arena of training, OSHA says, again, both employers have responsibility here. The staffing agency, because they are technically the employer of the employee in most instances, they are responsible at least for high-level, generalized, basic safety and health training. And then beyond that, for sort of the site-specific and task-specific training, OSHA's expectation is that without, more detail in a contract between the two parties and in the reality and how it's implemented in the field could modify this, but without those types of modifications, OSHA's expectation is that the host employer will be responsible for site-specific and task-specific training, because they're really the only ones in a position to deliver that kind of training. Then you go back to the staffing agency and say, okay, staffing agency, as the employer of the employee, we understand that you can't deliver, or you're not in the best position to deliver site-specific or task-specific training. You are responsible to ensure that the host employer to whom you are sending your staffing agency employees to, that you're ensuring that they are actually delivering on their obligation and making sure that that training is happening on a reasonable basis to believe that the training they're receiving is adequate. So that's at a high-level training, and then OSHA gives other examples and guidance about specific subjects like hazard communication. And hazard communication is really, I think, a perfect example of that, joint responsibility issue that OSHA is talking about. They talk about the staffing agency responsible for generic hazard communication training. If you don't know, we're talking about sort of the chemical right to know, educating employees about chemical hazards that they might encounter in the workplace. The staffing agency, as the ultimate employer, has responsibility to explain hazard communication generally, maybe how to read a safety data sheet, generally what chemical hazards might exist in a workplace. But the host employer, because it knows what chemicals are present and it knows what chemicals a specific staffing agency employee might encounter because of the tasks that they're going to be assigned to perform, the host employer is thus required to deliver that site-specific or chemical hazard category-specific training for those workers that they might encounter on the workplace. The other area where OSHA provides some guidance in this sort of joint responsibility area, or sort of identifying who's responsible, is in the category of injury and illness record keeping, an issue which, by the way, has become much more important now that OSHA has implemented its electronic record keeping rule. And so it's important for host employers and staffing agencies to understand who is responsible to record injuries, on their logs, who is responsible to report to OSHA hospitalizations, amputations, and fatalities if such a thing were to occur, and then finally, on whose books do we need to count these workers for determining whether we are covered by the electronic record-keeping rule, and then subsequently, if we are covered, which of the two employers, the host or the staffing agency, is obligated to submit the electronic data under the electronic record-keeping rule. And at the end of the day, the analysis is I say it's simple. The concept is simple. It might not be so simple to implement, but the idea is, and this is true in all cases, but it plays out here in this staffing agency relationship scenario, is whichever employer is providing day-to-day supervision of the worker, that is the employer whose log an injury belongs on. That is the employer who's responsible to pick up the phone and call OSHA if there is a covered hospitalization, amputation, or fatality, and that is the employer who must count that employee, even if it's a temporary worker, even if it's a part-time worker, even if they work very few hours. If you supervise them on a day-to-day basis, they count towards your employee count for that 20 to 249 to be covered by the e-record keeping rule, or that 250 plus to be covered by the e-record keeping rule. If you supervise the employee on a day-to-day basis, give them assignments, oversee the work they're performing, provide the tools and instrumentalities of the work, you own those injuries on your record-keeping log and on the e-record keeping process as well. So I'm going to jump ahead here to best practices so I can get this back to Lindsay to cover OSHA's multi-employer policy. Some best practices that we've, and this is sort of a combination of OSHA's recommendations and our recommendations, but both of us agree that the smartest thing that both host employers and staffing agencies can do is to have very clear contract language that specifies which entity is going to be responsible for which OSH-related responsibilities. You cannot, by contract, delegate away, regulatory requirements, but you can, by contract, designate who owns those requirements, at least, so that in practice they are being implemented that way. And by practice, you can define who's responsible for which regulatory requirements. So it's important to be clear in your contract, to enforce your contract, and to designate who's responsible for which safety-related responsibilities. And this is useful not only for, conveying to OSHA who's responsible for which, but it's also a great way to avoid things falling through the cracks. In other words, the host may believe that the staffing agency is training on a certain topic, and the staffing agency believes the host is training on a certain topic. If you are clear in your contract, it is less likely that those gaps will appear. We also recommend that as a host employer, even if there is a designation that the staffing agency will be responsible for most training, we do recommend that you conduct some level of new hire, new project, of safety orientation training, so that at least the basics at your workplace are conveyed to the individual workers or to the staffing agency. I mean, it may be that you've delegated responsibility to the staffing agency, but you should own some level of responsibility to convey to the staffing agency what the site-specific and task-specific hazards are, so that the agency can effectively convey that to their individual employees. Maintain open communications between temporary workers and the staffing agency throughout the relationship to make sure that there are no gaps in safety and health responsibilities arising. Identify hazards that may be uniquely relevant to temporary workers and develop protective measures, or work with the staffing agency to develop protective measures for those unique hazards. You should do your own assessment whether temporary workers may be deemed by OSHA or the OSH Review Commission to be your employees, despite the relationship or the contract that you have. You should evaluate periodically what's happening in the field to determine whether these workers are your employees or may be treated as your employees, and therefore whether you own more OSHA Act obligations than you realize. and then review your policies, procedures, and training to make sure that they effectively address any hazards in the workplace unique to temporary workers. You should obviously be doing that for all of your tasks and all of your employees, but relevant to this topic. Look for those maybe work that's only being done by your temporary workers and audit that like you would your more permanent tasks for your permanent employees.
All right, so our last topic of the discussion this afternoon is OSHA's multi-employer worksite enforcement policy. And I'll try to go through this pretty quickly as it is a policy that we have discussed prior, and there really haven't been many, if at all, changes to it in the new administration. So basically, a multi-employer worksite exists where there are 2 or more employers working at the same worksite toward a common goal or project. And where we see this a lot is a construction worksite where you have contractors and subcontractors on the site all performing different tasks toward building a building or some other structure. In these circumstances, more than one employer may be cited by OSHA if a hazardous condition is discovered during an inspection or if an accident occurs resulting in an employee's injury. And in this instance, the employer could actually be held liable even if its own employees weren't actually exposed to that hazardous condition. All of the different employers on the worksite have a different role, and OSHA assesses their liability based on the particular role that they have. So there are 4 main roles that an employer can have on a multi-employer worksite. The first is the creating employer, and as the name implies, the creating employer is the one that creates or causes a hazardous condition. So a creating employer can be cited for the creation of a hazardous condition where it does nothing to address that condition. Like I said, even if its own employees aren't actually being exposed to the condition. For example, an employer that damages the guardrail of a raised platform while hoisting a piece of scaffold would be the creating employer. And it would have to take steps to address the hazardous condition that it created, the damage to the guardrail, to ensure that its own employees as well as other employees are not actually exposed to that hazardous condition. The second type is the exposing employer. An exposing employer is one whose employees are actually exposed to the hazardous condition. For example, the exposing employer, based on the scenario I just discussed, would be the one whose employees are up working on that platform, working near the damaged portion of the guardrail and exposed to the hazardous condition. The exposing employer can be cited by OSHA if it has knowledge of the exposure and doesn't take one of the actions that are described on this slide, which is act within its authority to address the hazard. So if it can address the hazard itself, it must do so. Ask the creating or controlling employer to fix the hazard. If the exposing employer doesn't actually have control, can't actually make any repair itself, it needs to go to the creating or the controlling employer to do so. And then finally, inform its employees of the hazard and ensure that it's taking steps so that its employees are not actually exposed to the hazard. If the employer in this circumstance, the one that damaged the guardrail while hoisting a scaffold, also has employees that are being exposed to that condition that it created, it can be considered both the creating employer and the exposing employer and may be liable based on both of those roles. The third type is the correcting employer, and the correcting employer is the one responsible for correcting these hazardous conditions that might arise. This could be, in the scenario that I discussed with the damaged guardrail, it could be the carpentry contractor who has been hired to erect and maintain all the guardrails on site, if he is responsible for repair of any of the guardrails that might require it. This employer may be cited if he does not exercise reasonable care in finding and repairing those hazardous conditions within his particular designated responsibilities. So someone hired as a carpentry contractor wouldn't necessarily be cited if there was an issue that arose with the electrical system, because that is not his arena. But anything related to the guardrail, if that falls within his responsibilities, he would have the responsibility to exercise reasonable care in finding and making the necessary repairs. And then finally, you have the controlling employer. And this is usually going to be your general contractor. It's the employer that has general supervisory authority over the work site. And this employer has the duty to exercise reasonable care in preventing and detecting hazards. The extent of the measures that the controlling employer needs to take will be dependent on the circumstances of the particular work site. OSHA will consider such things as the scale of the project, the nature and pace of the work, as well as the controlling employer's knowledge of the other contractors and subcontractors on site of their safety history. So if the controlling employer knows that a particular contractor has a poor safety history, then exercising reasonable care in that case would require greater supervision by the controlling employer. Whereas if they know that a particular contractor has a pristine safety history, then less oversight would be required for the controlling employer to still exercise reasonable care in that circumstance. OSHA will evaluate the role of the employer based on its specific responsibilities on the work site. And as I said, a particular employer could fulfill more than one role depending on their particular obligations and whether they have employees on the work site. Under the multi-employer policy, compliance officers are directed to determine first whether an employer would be an exposing employer, as protection of an employer's own employees would be the priority, and then it would evaluate the other categories to see if there are any other obligations or roles being fulfilled by that employer. Although there have been cases that question OSHA's authority to hold employers liable for the safety of non-employees, it hasn't deterred OSHA from maintaining this multi-employer policy as well as attempting to enforce it. In a recent case, Hensel Phelps Construction Company, an administrative law judge did establish a potential limitation to the multi-employer framework, at least in the context of the Fifth Circuit. In that case, Hensel Phelps was cited in 2015 by OSHA as a controlling employer for permitting subcontractor employees to perform work in an unprotected excavation. During the case, the administrative law judge did determine that Hensel Phelps was the controlling employer, that it was aware of employees being in unprotected excavations, and that it did have the authority to actually stop work, and actually did in fact stop work at one point because of safety concerns. However, because the job site was in the geographical jurisdiction of the Fifth Circuit, the administrative law judge determined that ultimately the Fifth Circuit standard for the employment relationship would apply. And the Fifth Circuit in the past had clearly ruled that the OSHA Act and its implementing regulations serve to protect an employer's own employees from workplace hazard, and explicitly held that the employer could not be held responsible for instances of noncompliance if their own employees were not affected. So although the circumstances are very specific to the Fifth Circuit, it demonstrates how OSHA's multi-employer framework may be questioned based on how other adjudicatory bodies outside the Commission have interpreted the obligation of the OSHA Act and its regulations. One more quick notable thing about this, OSHA under the current administration did file an appeal of this decision to defend the legality and the applicability of its multi-employer policy. And this is significant because it demonstrates that OSHA, even under the Trump administration, does not intend to back down from the multi-employer policy and will likely continue to pursue it.
So we've got a couple of questions typed in here. There's a real interesting one about the BLS injury survey, and the question is with regards to the BLS reporting. And if you don't know, there's a sampling of employers across different industry sectors that the Bureau of Labor Statistics sends an injury survey to every year. And the question here is that as part of that survey, are companies also to include injury data for temporary workers? And the question is a very good question, and the person who asked the question notes that often employers, or maybe always employers, do not have all of the personal information or do not have as easy access to personal information from temporary workers as they do for W-2 employees. So a couple things to say about that. First is, yes, generally speaking, you are required to include injury data about temporary workers in the BLS survey response, and the reason why I say that is that generally what you're doing in that BLS response is plucking data out of your OSHA 300A annual summary record. And since the analysis here, well, I shouldn't say it goes back to my point earlier about if you supervise the employee on a day-to-day basis, even if he's a temporary worker supplied through a temporary staffing agency, if you're supervising them on a day-to-day basis, the injury goes on your log. That injury then and the number of days away or days of restriction or whatever it is rolls up to your 300A annual summary form, and then when you're completing a BLS survey response, you're plucking the data right out of that 300A form. So yes, you would need to include it. I also say that I pulled up, after reading the question, a copy of the 2017 version of the survey, and it identifies the list of workers whose injuries you are required to include in the survey response, and it identifies, just as OSHA does on its 300 log data, permanent, full-time, temporary, seasonal, et cetera. If they are an employee who you supervise on a day-to-day basis, you have to supply the data for those individuals. I'm just going to pop back real quick to the slide about record keeping here. One of the things that your note is, your question is a very good question, is that often we don't have access to the same information we would have for our own employee, like how many days away does the employee experience for the injury, because it may be that he's injured on the last day, or he's out of work for more days than would be the end of the project for which he was temporarily assigned to your workplace. The OSHA Act requires, and the Injury and Illness Record Keeping Regulations require, employers to make reasonable efforts to obtain information about worker injuries, including information like the severity outcome, the number of days away, et cetera. You're required to make that reasonable effort in all cases, including for temporary workers. And what's reasonable in terms of that effort for temporary workers is different than what is expected for permanent full-time employees, but you do have to make a reasonable effort, and that would mean contacting the staffing agency to ask whether the employee has been physically able to return to work, or if the staffing agency has obtained information from a medical provider about how long the worker is expected to be out, or what would be a normal or expected period of time for that employee to be out. And then here's a good question here about what's the HIPAA standard for the staffing agency giving medical information to host employers. The answer is it's no different than the standard for information available about your own employees. You have to make sure that you're not crossing that line, but you have a legal obligation to inquire about severity outcomes, if not specific diagnoses. And when I say severity outcome, I'm talking in terms of the record-keeping logs, like did it result in days away from work? And you can get that information generally without crossing a line of specific medical diagnoses or specific health information. Did it rise to the level of requiring a work restriction? Those are the types of things that you're trying to track down without understanding or without inquiring into protected health information. Where it gets tricky and where you get much closer to the line is when you're trying to determine whether an injury is work-related. And, that's a tougher inquiry. You've got to make it. You've got to make reasonable efforts to do that. And often you run into a brick wall, either with a medical provider or the staffing agency. And if you're not able to get that information despite reasonable efforts, then you make your best judgment about whether something's recordable, how to record it, make your own estimates of days away. The idea is that you just make a reasonable effort. I think that is all the questions that I see. If any others come in, we'll address those, but I do want to make my monthly plug to check out our blogs. the OSHA Defense Report and the Employer Defense Report. Lots of great content on there that we work really hard to keep fresh, so please check that out. And a new plug this month, if you are in an industry that intersects with OSHA's Process Safety Management Standard or EPA's Risk Management Plan rule, I encourage you to join us in October for the first annual Process Safety Summit in Washington, D.C. We're going to be joined that day for a full-day program with senior leaders within OSHA, the Chemical Safety Board, EPA, the trade groups, AFPM, API, and others that have members who are interested stakeholders in process safety issues. And we're going to be reviewing the current lay of the land from a regulatory standpoint, as well as best practices and some benchmarking opportunities over breakout roundtable sessions. So if this is in your wheelhouse, something that affects your company, check this out. It'll be up on our blog here in the next day or so. And I encourage you to send representatives to that. It's going to be an outstanding program and hopefully the first of many annual events like that. And then here's the contact information for Jordan, Lindsay, and me. If you have any questions about anything we covered today or any other labor and employment or OSHA topics, we would love to hear from you and to be a resource for you. So thanks very much for tuning in today. We will get you a copy of the slides and a recording of the program as soon as we're able, and we hope you join us for the rest of the series. Thanks so much.